is asking, Angela, ask him about jurisdictional challenge. What happens when they don't answer or give written action, such as frivolous paperwork?
Oh, that's easy. You just like I said, when you have when you challenge jurisdiction, it's called a claim of consuance. It's CONSUANCE. And that's a claim of consuance. So if anybody tries to drag you to the wrong side of the court, you just file a claim of consuance. And a claim of consuance is simple. I think I put one on your site. If not, I'll mail it to you guys if you want me to mail you a claim of consuance. It's 1 page long.
Okay. I'll put it up there.
Yeah, all it says is, you got me in the wrong jurisdiction, and all jurisdiction means is control or power over somebody else. Like if you're standing on my feet and you're breaking my toes, I have jurisdiction over you. Now I could grab you and control you and do whatever I want to you because I have the power to control you, and that's the 10th Amendment. And that's what the 10th Amendment says, is that people have the power. And power just means to control somebody else. So if you're standing, in my space, on my toes, like people say, hey, that's my space, back up a couple of feet. You're in my space. You're claiming that's your jurisdiction. And nobody could get 2 inches of you. And like you could say, you know what, you need to back up. And you have that right to do it. It's a right. By God, you could say you're breaking my toes and I'm going to force you off my toes. So that's all jurisdiction is. Jurisdiction is pretty simple to understand. So when they try to control your paperwork, or they try to control you, or try to drag you into their court before their judge, you're like, hell no. I want to go before a jury. I'm not going before no man in no black robe. You're not my friend. I didn't go to law school with you. I don't go to the same golf club with you. I don't go to lunch with you. I'm not going to stand in front of you because that prosecutor is your buddy or is your sister-in-law. I'm not dealing with you. I want a jury. So when they try to drag you in front of them, say you got the wrong jurisdiction. You got no control of jurisdiction over me because in this country it's a common law land. Oh yeah, the Marshal Service loved that. I gave them a map of the world, and there's like just a few common law countries left. And I had it colored. I said, look, these are the orange ones. These are the blue ones. This is all civil code. This is all common law. I said, we live in a common law land. I said, so if we want to drag somebody out of civil court or tax court or bankruptcy court or divorce court or any court, DMV, we could drag them into the common law side. I said, if we lose that ability to drag them over to the proper jurisdiction where we have control over them, I said, we're going to wind up like France. And I said, like all these blue countries in Europe, we're going to be like France. I said, I don't mind. I said, my grandma's from France. My dad's whole family's from Germany. I said, they all live civil. I said, we're not all in jail over there. I said, but if we turn to France, I said, then we're all guilty until we can prove ourselves innocent. It's going to be backwards. We're going to live in a code land. I said, right now we live in a common law land. So I love living in a common law land. So anytime somebody tries to drag me into the code world, I'm going to drag them into the common law side. I said, if I was in France, I couldn't do it. If I said, well, let me drag you into the common law side, they'd laugh at me. They'd say, go move back to the USA. We don't do common law over here. We do code. So I told them, man, I said, if all I'm doing when I'm making contact with the judges on that side, I'm demanding from them that they respect the fact that they're Article III judges and this is a common law land. And if they don't like, working in a common law land and as common law judges, I'm going to have to ask for their oaths of office. Because a claim of consequence is just that if you're trying to hold it in a common law court or a court of record, or you're trying to hold it in a tax court, and all of a sudden you realize they're shifting the jurisdiction on you, you go, whoa, where are you going with this? Bring it back over here to my court of the original jurisdiction. I have the original jurisdiction over here. I made the claim in this type of court. Why are you dragging it over to admiralty or maritime or tax court? Like I said, if it was an Aaron Schiff kind of guy, I'd say, Aaron Schiff should have filed a suit in just a normal state court because every state court is a common law court. And if they tried to use tax code on him, he should have said, whoa, why are you trying to drag my lawsuit into a tax court? Or why are you trying to use tax code jurisdiction or federal tax, U.S. court tax court jurisdiction? Why are you trying to control or answer my claim? You can't answer my claim under a code. I didn't write that code. I'm not going to here to decipher that code. I'm just saying that you had no right to administrate my property or my revenue or my sales or my books. I believe you have no right to do that. I believe I have the right to contract with any other person on this planet, and the United States government doesn't have the right to interfere with that contract. And it's like, doesn't the Constitution, Article 1, Section 10, clearly say that the government can't interfere with a contract between a man and between the persons? So if I want to contract with Fidel Castro in Cuba, what right does the United States government have to interfere with that contract? Or if I want to sell my book to this other man and we're making a contract and we're exchanging something tangible for something that I believe has got value, who is the United States government to interfere with that transfer of property? Can somebody from the United States government come forth and say that I can't sell my book to anybody I want? And under the common law. Because the attorney for the government can't do it. A man who's been harmed by you selling your book to another man has to appear in court and say, well, because you sold your book to that man over there, I was directly harmed. Good. Show me. Give me the bill of particulars, and I'll compensate you. But you can't just make a blanket statement by me selling a book to the general public is causing you, a man, harm. You have to show me. Is it destroying your reputation? Is it damaging your good name? Am I committing fraud? Am I lying? Am I committing perjury in my book? What am I doing? Am I slandering your good name? What am I doing? You're going to have to make a claim, and you're going to have to show me how you expressly damaged, not conjecture, not implied how you were damaged. You're going to have to show me the bills of the damages. You're going to have to show me. So like I said, when the people ask me the claim of consequence, I like that one because it's an old one and nobody ever does it. And I think it's super simple. All it is basically when anybody, like I said, when the governor for the attorney said to him, it's in the first paragraph that the district court wrote in first order, how many jurisdictions did he try to throw in that first paragraph? He said 4. I said, yeah, he tried to drag me out of the common law. He's trying to drag me under the United States codes. He's trying to drag me into his personal jurisdiction. And he's trying to hold me, liable to the federal rules of civil procedure. He's trying to bounce me out of the common law. And if he could get away with it, he's going to keep it up. He's going to bounce me all different jurisdictions. So, like I say to people, when they try to move you to jurisdiction, if you don't object, they're going to run you over like a freight train. It was like I say to people, it's like if you write the word like pro se or proper persona, and you start using Latin terms like in camera and stuff like that, they could answer you in Latin terms. If you're speaking Latin terms in your claim, they could speak Latin terms in their claims. So how would you like it if they put 1,000 Latin terms in their answer to you? Well, you're the one who started Latin. They're going to reply to you in Latin. And that's why I say to you, if you're going to say, well, I'm going to file a Title 42, 1983 claim, well, they're going to give you an answer that just says 12b6. And you folks are going to be like, what's a 12b6? And they're going to like, well, you're the one who started with the number codes. We answered you with a number code. So if you want to talk in numbers and codes, if that's how you're going to make your claims, we're going to answer you in numbers and codes. So you better be up on your codes. Or if you say, well, I'm relying upon the Erie Doctrine to move this case, they're going to say, well, according to the Feldman-Roken Doctrine, you can't. And they're going to say, but what's the Roker-Feldman Doctrine? It's like, well, any 3-year law student knows it. They spent 3 semesters on a Roker-Feldman Doctrine. You should know it. You just threw the Erie Doctrine out of this, but so obviously you must know the Roker-Feldman Doctrine counters the Erie Doctrine. So if you want to throw the Erie Doctrine at us, we're going to throw the Feldman Doctrine at you. That's
okay,
our answer.
Stop for a second. Take a breath.
Well, see, it's conusance.
Conusance? Yeah. How does that work, and what does it work on? What can you use it for, and how effective has it been so far that you've seen?
All right. Well, we got 14 minutes. I'll do it real quick. The history of conusance is extremely simple. At one time, like the King of England and you had the King of France, I'll give you a simple example with them. Say there was the King of France agreed to send over the King of England certain subjects, of his to be under the control of the King of England as servants or something like that, whatever he wanted, ladies in waitings, whatever. The lady-in-waiting had it up to here with the Queen of England, so she decided to go back to the court of France, the King of France. So what would happen is the king would say, look, I gave you 300 bushels of wheat for a French lady-in-waiting. Where the hell did she go? If you got her hiding over there, we demand her back, and we demand her back now. So the King of France would look around in all his castles and say, there she is. You got to go back. And she's like, no, I'm a French citizen. I'm subject. No, you got to go back. You're in the wrong court. And that's all I'm saying with a claim of conusance. Wow, I did that pretty quick. Did that in 1 minute. A whole claim of conusance is saying that you got me in the wrong court. I want to go back over here where I belong.
Mm-hmm.
See, that's what I'm saying. I just happened to find this because, like I said, I live right next to a law library. I made sure I lived on the other side of the mountain of a law library when I wrote my dictionary. And I just happened to really like reading Old English law. And I said, oh, wow, this is how you get your property from one court into the proper court, and this is how you make a claim for it. I like this.
Right,
so like I said,
right.
You're not going to find it. I guaranteed you Googled it, and you can't find it freaking nowhere, can you?
Not a whole lot of information about it. I mean,
Right.
I read it in Black's Law Dictionary. I saw that some information about it there, but there, when I put it in Google, there's not a lot. I mean, they had dictionary definitions of the word, but nothing regarding actually what it is, how it's used, and there was one document that I found on the internet that had a little bit of information about someone put on there, but it wasn't anything where you could actually use it in a court setting.
But now the way I explained it, do you see how you could probably use that in a court setting?
Yeah, they get it out of their jurisdiction and put it into yours.
Right. So I'm saying, it's just basically yes. Can you basically see how this would be useful the way I described it?
Yeah. Yeah. Absolutely. Yeah.
Absolutely. And the lawyers don't want to tell you anything that actually works. They want to give you this razzle-dazzle nonsense that they have control over.